Chapter XV, Consideration, SS 207, concerning consideration and good faith. Consideration has been said to consist either in same right, interest, profit, or benefit accruing to the one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. The subject cannot be here considered from an elementary point of view in all its ramifications, but its general bearing upon our particular topic will be briefly noticed. It will be found upon investigation that, generally speaking, the question of consideration becomes important in the class of litigation under discussion only in bona fide transactions, if the alienation is effected with a mutual design to hinder, delay, or defraud creditors. The presence of even the most bounteous or adequate consideration will not save or cure it. Thus, a mortgage, though given for a just debt, may be assailed as fraudulent. Unilateral evil intent will not, of course, suffice to overturn the transaction. Mala fides, says Mr. May, supersedes all inquiry into the consideration, but bona fides alone is not always sufficient to support a transaction not founded on any valuable consideration. The inadequacy of the consideration, as is elsewhere shown, is not a matter which the court will go into, except in so far as it may constitute evidence tending to show that the transaction was a sham. And the law will not weigh considerations in diamond scales, though grossly inadequate consideration will render a conveyance fraudulent. The avoidance may be only to the extent of the inadequacy, generally speaking. As we have already seen, the question whether a conveyance is fraudulent or not depends upon its being made upon good consideration and bona fide. It is not sufficient that it be upon good consideration or bona fide. It must be both. The separation of these elements is fatal to the transaction as against creditors. This rule is concisely stated in a recent case of much importance in the United States Supreme Court. It is not enough, says Woods, J., in order to support a settlement against creditors, that it be made for a valuable consideration. It must be also bona fide. If it be made with intent to hinder, delay, or defraud them, it is void as against them. Although there may be in the strictest sense a valuable or even an adequate consideration, forms, said Elliott, J., in a very recent case, are of little moment, for where fraud appears, courts will drive through all matters of form and expose and punish the corrupt act. A conveyance is not protected, although full consideration is paid, where grantor and grantee unite in a fraudulent design to defraud creditors. SS 208. Voluntary Conveyances. It is perhaps unnecessary to observe that a voluntary conveyance implies the total want of a substantial consideration, or is a deed without any valuable consideration. Such a transfer is more easily susceptible to attack than a conveyance founded upon an adequate consideration. For a transfer by a debtor without consideration, made for the purpose of defrauding his creditors, can be impeached by the creditors for fraud, even though the grantee was ignorant of the fraudulent purpose for which the covenant's conveyance was given. The onus of establishing a fraudulent intent is avoided, and Levy Fig. The court observed that whether the voluntary alienee participated in and aided the covenant's intent or not was immaterial. He was not a purchaser in good faith. The distinction may be restated as follows. A voluntary gift or settlement is voidable if it was the intent of the maker to hinder, delay, or defraud creditors, whether the party who received the gift participated in the fraudulent intent or not. An absolute conveyance for a valuable consideration is good, notwithstanding the intent of the maker to defraud, unless the other party participated in the fraud. We have elsewhere shown that, in the majority of the cases, a voluntary alienation is regarded as presumptively fraudulent as to existing creditors, while in other cases this presumption is conclusive, where, however, a corporation or individual, perfectly solvent at the time, and having no actual intent to defraud creditors, disposes of lands or property for an inadequate consideration, or by a voluntary conveyance, subsequent creditors of the corporation cannot question the transaction, if, as we have seen, it was made with the design to defraud subsequent creditors. This will render it fraudulent. It must be remembered, however, that in New York the question of fraudulent intent is in all cases to be deemed a question of fact and not of law, and it is declared that no conveyance or charge shall be adjudged fraudulent as against creditors or purchasers solely on the ground that it was not founded on a valuable consideration. It is not per se void even as to existing creditors. SS 209. What is a valuable consideration? Much has been said concerning the true import of the expression a valuable consideration. Certainly a money consideration for an assignment of goods greatly disproportionate to the value of the property transferred would not take a conveyance out of the statute against covenant alienation. the consideration must be adequate. Not that the courts will weigh the value of the goods sold and the price received in very nice scales, but after considering all the circumstances they will hold that there should be a reasonable and fair proportion between the price and the value. Cases in which the question of inadequacy of consideration arises between the grantor and grantee of a deed, where suit is instituted for the purpose of setting aside the grant on the ground of imposition, are not applicable in determining a question of the fairness of a consideration between a vendee and creditor under the statute concerning fraudulent conveyances. Such inadequacy of consideration as would induce a court to set aside a conveyance at the instance of the grantor on the ground of imposition presents an entirely different question from that degree of inadequacy which would avoid an assignment on the ground of fraud. In a suit instituted by a creditor or purchaser against the alleged fraudulent assignee, a grantor must of necessity make out a stronger case, calling for the interference of the courts, than a creditor, because the latter is not a participant in the transaction, is guilty of no negligence or fraud, and belongs to a favored class. Unreasonable inadequacy of price is evidence of a secret trust, and it is said to be prima facie evidence that a conveyance is not bona fide if it is accompanied with any trust. In Cook v. Tully's, the court observed that a fair exchange of values may be made at any time, even if one of the parties to the transaction be insolvent. It is said in the New York Court of Appeals that a valuable consideration is something mutually interchanged between the parties, and that it is not necessary that the subject matters should be of equal values. It is also established that a gratuity cannot be subsequently converted into a debt so as to become the consideration of a conveyance made by the grantor to the injury of his creditors. SS 210. Love and Affection. In Matthews v. Fever, Sir Lloyd Kenyon said, "This is a transaction between the father and the son, and natural love and affection is mentioned as part of the consideration, upon which, as against creditors, I cannot rest at all. It is true it is a consideration which, though not valuable, is yet called meritorious, and which in many instances the court will maintain, but not against creditors. Natural love and affection is a sufficient consideration for a gift or voluntary transfer between a brother and a sister. But as a general rule, a conveyance for such a consideration cannot be supported against the rights of existing creditors." It was said in Hinds Lessee v. Longworth, and the rule is still good, that a deed from a parent to a child, for the consideration of love and affection, is not absolutely void as against creditors. It may be so under certain circumstances, but the mere fact of being in debt to a small amount would not make the deed fraudulent, if it could be shown that the grantor was in prosperous circumstances and unembarrassed, and that the gift to the child was a reasonable provision according to his state and condition in life, and leaving enough for the payment of the debts of the grantor. The same principle appertains generally to conveyances founded upon such consideration. SS 211. Transfer for grantor's benefit, as was observed by Peck, J. in Stanley v. Robbins. One cannot transfer his property in consideration of an obligation for support for life, or perhaps for support for any considerable length of time, unless he retains so much as is necessary to satisfy existing debts. In Crane v. Stickles, the court said, "It seems that 1 week before the plaintiff's note fell due, they took a sweeping sale of all the property of which the defendant was possessed, real and personal, and obligated themselves that they would support her for the same, as the only consideration, paying nothing and agreeing to pay nothing, only by way of support, and leaving nothing for the payment of debts. Now, if the law would tolerate a proceeding like this, any person, having the means, may make ample provision for himself and family during life, at the expense of his creditors, but that would not be permitted." SS 212. Anti-Nuptial Settlement. Marriage as consideration. An anti-nuptial settlement, though made by the intended husband with the design of defrauding his creditors, will not be set aside in the absence of the clearest proof of the wife's participation in the fraud. In Magniac v. Thompson, the court said, "Nothing can be clearer, both upon principle and authority, than the doctrine that to make an anti-nuptial settlement void as a fraud upon creditors, it is necessary that both parties should concur in, or have cognizance of, the intended fraud. If the settler alone intended a fraud, and the other party have no notice of it, but is innocent of it, she is not and cannot be affected by it." Marriage, in contemplation of the law, is not only a valuable consideration to support such a settlement, but is a consideration of the highest value, and from motives of the soundest policy is upheld with a steady resolution. The courts are averse to annulling such a settlement, because there can follow no dissolution of the marriage which was the consideration for it. The marriage subsists in full force even though one of the parties should forever be rendered incapable of performing his or her part of the marital contract. Marriage is not only a valuable consideration, but, as Koch says, there is no other consideration so much respected in the law. The wife is deemed to be a purchaser of the property settled upon her in consideration of the marriage, and she is entitled to hold it against all claimants. In Stary v. Arden, Chancellor Kent observed, the marriage was a valuable consideration, which fixed the interest in the grantee against all the world. She is regarded from that time as a purchaser, and as much so as if she had then paid an adequate pecuniary consideration. It is the constant language of the books and of the courts that a voluntary deed is made good by a subsequent marriage, and a marriage has always been held to be the highest consideration in law. It is unnecessary to dilate upon this branch of the subject. Where the wife participated in the fraudulent intent and scheme, the transaction may of course be annulled. The difficulties of implicating the wife in the fraudulent scheme are from the very nature of things often insuperable. Our meaning is illustrated by the language of Mr. Justice Field in a recent case which we have frequently cited. It is not at all likely, judging from the ordinary motives governing men, that, whilst pressing his suit with her, and offering to settle property upon her to obtain her consent to the marriage, he informed her that he was insolvent, and would, by the deed he proposed to execute, defraud his creditors, if he intended to commit the fraud imputed to him. It is unreasonable to suppose that he would, by unfolding his scheme, expose his true character to one whose good opinion he was at that time anxious to secure. If capable of the fraud charged, he was capable of deceiving Mrs. Prewitt as to his pecuniary condition. She states in her answer that she knew he was embarrassed and in debt, but to what extent, or to whom, she did not know, and that it was because of the knowledge that he was embarrassed that she insisted upon his making a settlement upon her. This is perhaps an extreme case, but it illustrates the statement already advanced, that the creditor will be forced to travel a thorny pathway to annul an ante-nuptial settlement. It is sometimes urged that the court should not encourage a practice the result of which is, so to speak, to allow a man to barter for a wife for a pecuniary consideration. This is scarcely a fair view of the transaction. By marriage the woman assumes new duties and responsibilities, forsakes a home to which the marriage will ordinarily unfit her to return, promises to live with her husband, and to bear her share of the burdens and cares of the family. Surely in assuming these responsibilities she is entitled to guard against poverty and distress. SS 213. Illicit intercourse. A contract the consideration of which is future illicit cohabitation is said to be utterly void, but a conveyance in consideration of past cohabitation, intended or regarded as reparation or indemnity for the wrong done, is treated at common law as founded on a good consideration, and may be upheld. A transfer, however, to a mistress or her children, by way of gift or advancement, although not looking to future cohabitation, and intended merely as a provision for maintenance, is invalid as against existing creditors. This distinction is manifestly important. In Waite v. Day the court said that although the debtor may have been under no legal liability to the defendant, yet if he paid the money in discharge of what he deemed a moral obligation to indemnify the defendant against the consequences which had already resulted from their illicit intercourse, I think the case would not be within the statute. He had made her the mother of 2 illegitimate children, and was at liberty to refund the money which she had already expended for the necessary support and education of those children. Where there is an existing obligation, either legal or moral, to pay so much money, and the payment is not made with any reference to the future, nor by way of mere gratuity, the case is not within the mischief against which the legislature intended to provide. The same principle was applied in Fellows v. Emperor. In that case the grantee had been deceived into a marriage with the grantor, and had innocently lived with him for years, supposing she was his lawful wife. It subsequently transpired that he had another wife living, whereupon she left him. The court, in sustaining the conveyance, held that the grantor was under the strongest moral, if not legal obligation, to compensate the grantee for her services, and to indemnify her as far as he could in a pecuniary point of view, against the consequences of his fraudulent and illegal acts. The conveyance was upheld against creditors. SS 214. Illegal consideration. One who has freely paid his money upon an illegal contract is particeps crimines, and no cause of action arises in his favor upon an implied promise to repay it. But when an insolvent debtor, or one in embarrassed circumstances, pays his money upon such illegal consideration, he stands, in relation to his creditors, in the same position as if he had made a voluntary conveyance of his property. In contemplation of law, he has in fact parted with his money for no consideration, because it is no consideration which can be set up in a court of law. SS 215. Moral obligations. A debtor may acknowledge and prefer a claim barred by the statute of limitations, and such conduct is not conclusive evidence of a want of good faith, and he is not bound to set up the statute of frauds, and an agreement by a husband to convey certain lands to his wife in consideration of her relinquishing an interest in his lands, which she carried out, is founded upon a valid consideration which the husband had a right to discharge, so it is not absolutely necessary to the bona fides of a charge of interest in an account that it should be of such a character that it might be recovered in a suit at law brought by a creditor against his debtor. There are many dealings amongst men in which interest is habitually charged and paid, when it could not be claimed on the ground of strict legal right. These transactions are regarded as fair and just as between the parties, and they cannot be considered fraudulent as to others. SS 216. Individual and copartnership debts. One partner, it is asserted, cannot usually make a valid transfer of firm property in payment of his individual debt without the consent of his copartner. It is said that everyone is bound to know that a partner has no right to appropriate the partnership property to the payment of his individual debts, and if one so deals with him, he must run the risk of the interposition of partnership rights. This broad proposition is disputed in Schmidlap v. Curry. The court said, the firm creditors at large of a partnership have no lien on its assets, any more than ordinary creditors have upon the property of an individual debtor. The power of disposition over their property, inherent in every partnership, is as unlimited as that of an individual, and the justus bonendi in the firm, all the members co-operating, can only be controlled by the same considerations that impose a limit upon the acts of an individual owner, namely, that it shall not be used for fraudulent purposes so long as the firm exists. Therefore, its members must be at liberty to do as they choose with their own, and even in the act of dissolution they may impress upon its assets such character as they please. The doctrine that firm assets must first be applied to the payment of firm debts, and individual property to individual debts, is only a principle of administration adopted by the courts, where from any cause they are called upon to wind up the firm business, and find that the members have made no valid disposition of, or charges upon, its assets. A transfer by one of the partners, or a lien created by him on the corpus of the partnership property to pay an individual debt has been in effect declared in New York to be fraudulent and void as to the creditors of the firm, unless the firm was solvent at the time. But Chief Justice Ruger said in Crook v. Reinskopf, it is lawful for an insolvent member of a firm to devote his individual property to the payment of firm debts, to the exclusion of his individual creditors. The authorities as to what dispositions of individual or of copartnership assets will be upheld as against the respective classes of creditors are not in very satisfactory shape. It seems perfectly clear, however, that where the courts get possession of the funds for distribution, the distinction between the rights of the two classes of creditors will be respected and preserved. SS 217. Future advances. A judgment or mortgage may be taken and held as security for future advances and responsibilities to the extent of the security, when that forms a part of the original agreement between the parties. It is frequent, says Chief Justice Marshall, for a person who expects to become more considerably indebted to mortgage property to his creditor as a security for debts to be contracted, as well as for that which is already due. But in order to secure good faith and prevent error and imposition in dealing, it is necessary that the agreement, as contained in the record of the lien, whether by mortgage or judgment, should give all the requisite information as to the extent and character of the contract. SS 218. Services by members of a family. In the absence of an express agreement, the law will not imply a promise to pay a daughter for services rendered in the debtor's family, and a mortgage given to a daughter under such circumstances will be held to be without consideration and fraudulent as against creditors. A conveyance by an insolvent husband to his wife, in pursuance of a contract to compensate her for services in taking care of his aged mother, who resided with him, has been held in New York to be invalid and voidable as against creditors. The Court of Appeals of that state decided that the wife, by rendering service to her husband's mother, was simply performing a marital duty which she owed to her husband, that where she received no payment for the discharge of this duty from the person to whom the service was rendered, and was entitled to none, and brought no money or property to the husband by her service, she could not stipulate for compensation. Earl J. said, "It would operate disastrously upon domestic life, and breed discord and mischief if the wife could contract with her husband for the payment of services to be rendered for him in his home, if she could exact compensation for services, disagreeable or otherwise, rendered to members of his family, if she could sue him upon such contracts, and establish them upon the disputed and conflicting testimony of the members of the household. To allow such contracts would degrade the wife by making her a menial and a servant in the home where she should discharge marital duties in loving and devoted ministrations, and frauds upon creditors would be greatly facilitated, as the wife could frequently absorb all her husband's property in the payment of her services, rendered under such secret, unknown contracts." SS 219. Proof of consideration in Hanford v. Archer, in speaking of the presumption of fraud arising from a failure to change possession. The court said that, to rebut this presumption, the statute imposed upon the party claiming under a sale or a mortgage the burden of proving good faith and an absence of any intent to defraud creditors. Proof of a valuable consideration, said Senator Hopkins, or an honest debt, is essential to show good faith, and, if there be no such proof, I take it that the requirement of the statute in this respect is not complied with, and that the court may order a non-suit. Such proof of consideration, too, must go beyond a mere paper acknowledgement of it that might be binding between the parties. It is said by Chief Justice Eliot, in Rose v. Coulter, that if it be shown that a valuable consideration was paid for the property, and that when the sale was made the seller was possessed of property far more than sufficient to pay all his debts, the presumption arising from the retention of possession is plainly overcome. As we have already said, there ought to be a fair and reasonable consideration corresponding to the value of the article sold. SS 220. Recitals of consideration as evidence. It is said in Hubbard v. Allen, that when a controversy arises between the grantee and an existing creditor as to the validity of a conveyance, it is a settled rule to regard the recital of a consideration as a mere declaration or admission of the grantor, and not as evidence against the creditor. SS 221. Explaining recitals. A conveyance of land made by a husband to his wife purported to be executed in consideration of love and affection, and for the sum of $1 cash in hand paid, the receipt whereof is hereby acknowledged. The court held that, the money consideration being manifestly nominal, parole evidence was inadmissible in an action brought to set aside the deed as in fraud of creditors, to show that there was in fact an adequate pecuniary consideration. But, in another case, where the consideration expressed in the deed was $500 and other good causes and considerations, it was held competent to prove the consideration of blood. This general subject is referred to in Hinds Lessee v. Longworth, where it was said that if the evidence had been offered for the purpose of showing that the deed was given for a valuable consideration and in satisfaction of a debt, and not for the consideration of love and affection as expressed in the deed, it might well be considered as contradicting the deed. It would then be substituting a valuable for a good consideration, and a violation of the well-settled rule of law that parole evidence is inadmissible to annul or substantially vary a written agreement. The subject was further considered in Betts v. Union Bank of Maryland, a case argued by Reverdy Johnson on one side, and by Roger B. Taney, afterward Chief Justice of the United States, on the other. And the conclusion of the court was that marriage cannot be given in evidence as the consideration of a deed of bargain and sale expressed to be made for a money consideration only. A mortgage, the express consideration for which was $1,000, may be explained by showing that it was in fact given to secure the mortgagee against liability on 2 accommodation notes of $500 each. A recital that the consideration has been paid may generally be contradicted by parole evidence. And indeed there seems to be a prevalent tendency in the courts to admit parole proof of the true consideration of a deed in almost every case, though the fight is kept up to exclude evidence of consideration different in kind from that set forth in the instrument. Manifestly the recitals are not binding upon creditors in any event. SS 222. Sufficient consideration. A bond given by a minor son to his father in consideration of permission to leave home and work for himself, or for his board while he remains at home and works on his own account, if bona fide, is neither against the policy of the law nor fraudulent as to creditors, and where a wife advances to her husband money to purchase land, under an agreement that the money shall be repaid to her children and its payment secured by mortgage. The contract is valid and may be set up as a defense to a suit charging the husband with mortgaging the lands to his children in fraud of creditors. SS 223. Insufficient consideration. A deed from a debtor to his creditor is voluntary and not founded on a sufficient consideration if it is given for a pre-existing debt which was afterward treated by the parties as still due, and as against creditors of an insolvent. A party cannot make title to his property as a purchaser for a valuable consideration, where what purports to be the consideration is a debt against a third person which is found as matter of fact to be worthless. And this is true even though the transaction was in good faith on the part of the vendee.